The realtor called on a Thursday at 11 in the morning. I was at my desk reviewing a set of accounts that had the particular smell of something arranged rather than organic. The smell I had learned to recognize over 9 years of forensic accounting, and I almost let the call go to voicemail. I answered because the prefix was local, and I was not expecting anything local. The realtor said, "Good morning, is this Anna Sheridan?" I said yes. He said, "And calling to follow up on the listing documents you submitted last week for the Keene Lake property." He said, "We have had 3 inquiries and I wanted to let you know that one of the parties is very interested and has indicated they would move quickly." I said, "I am sorry." I said, "Which property?" He said, "The Lake Cottage on Keene Road." He gave the address. I said, "I did not submit any listing documents." There was a pause. He said, "The documents were received by our office on the 14th. He said, "They included a signed listing agreement and a notarized power of attorney authorizing a third party to act on behalf of the owner." He said, "The name on the documents is Anna Sheridan." I said, "I did not sign any listing documents. I did not authorize any power of attorney." I said, "Can you tell me who submitted these documents?" There was another pause. He said, "They were submitted in person by a Mrs. Vivian Sheridan." He said, "She identified herself as the owner's mother-in-law acting under the power of attorney." I said nothing for exactly 4 seconds. I counted them. Then I said, "I would like you to remove the property from your listings immediately." I said, "I would like you not to proceed with any of the interested parties." I said, "I will be calling you back within the hour." He said, "Of course." He said, "I want to be clear that if there is any irregularity in these documents." I said, "There is." I said, "Thank you for calling." I hung up. I sat at my desk for exactly 30 seconds. Then I picked up my phone and I called my father's estate attorney. "My name is Anna Sheridan. I am 34 years old. Dan is 37. We have been married for 4 years. The Lake Cottage on Keene Road was my father's. He built the dock himself in the summer of 1987 with his brother and 2 friends and a set of instructions he had ordered from a boat building catalogue. He had shown me the dock every summer of my life. He had shown me the knots he used and the way the boards needed to breathe in winter and the specific morning light that came off the water at Keene Lake in June that he said was the best light of anywhere he had ever been. He died 2 years ago. He left the cottage to me. It was in my name and only my name, because my father's attorney had advised at the time of the estate that inherited property retained cleaner title when not commingled with marital assets, and we had followed that advice. My husband Dan had agreed. 18 months ago, on the further advice of the same estate attorney, we had placed the cottage in a family trust. The reason was simple. My father's attorney had said that a property held in a family trust required the agreement of all trustees to be sold, transferred, or encumbered. There were 2 trustees, M.E. and Dan. Both signatures, verified independently, were required for any transaction. Vivian did not know about the trust. I had told Dan. Dan had not told his mother. His mother did not know. I dialed the estate attorney's number. I said, "Vivian Sheridan has presented a forged power of attorney to a real estate agent and listed the Keene Lake cottage without my knowledge." He said, "When?" I said, "The 14th, which is 9 days ago." He said, "Has the property been sold?" I said, "There is an interested buyer, but no sale has closed." He said, "The trust protects you from the sale closing." I said, "I know." I said, "But I want to understand everything she has done, and I want to know what the next steps are." He said, "Anna," he said, "I want to ask you a question before we talk about next steps." He said, "Is this something you want to resolve within the family? or something you want to address through every available channel? I said, all available channels. I said, every single one. He said, I thought so. He said, call me from your office in 1 hour. Let me make some calls first. Let me tell you who Vivian is before I tell you what she had built. Because the forged power of attorney did not arrive from nowhere. It arrived from a very specific place that I had been watching develop for 4 years and had not yet named clearly enough for what it was. Vivian is 61 years old. She is Dan's mother, and she is the kind of person whose love for her son comes packaged with a very precise and consistent belief about how his life should be arranged. The belief, stated plainly, is that a man should control the material things in a marriage, and a woman should be grateful for them. She had never said this directly to me. She had said things around it for 4 years. She had said things like, Dan is so generous with you, and she had said things like, it must be lovely having your own little cottage, and she had used the word your in that sentence with an intonation that placed you in slight distance from Dan rather than alongside him. She had asked once, about a year into the marriage, whether we were going to put the cottage in joint names. I said the cottage was an inheritance, and we had chosen to keep it in my name, for estate reasons. She said, of course. She said, but Dan should be on it somewhere. I said, Dan and I are both comfortable with the arrangement. She did not say anything else that evening, but she said it in her own internal register, and she filed it, and it sat there for 3 years developing into a plan I would not learn about until a realtor called me on a Thursday at 11 in the morning and mentioned my name on documents I had never seen. Now let me tell you about the power of attorney document, because it is the part of the story I find most clarifying about what Vivian had built and how long she had been building it. A power of attorney is a legal document by which a person grants another person the authority to act on their behalf in legal and financial matters. To be valid, it must be signed by the grantor in the presence of a notary public, who verifies the identity of the signer and witnesses the signature. The document Vivian had submitted bore my name, and what appeared to be my signature, notarized by a woman named Carolyn Marsh, listed in the document as a commissioned notary public. I am a forensic accountant. I have spent 9 years examining documents for financial crimes investigations. I examined the power of attorney within 2 hours of the realtor's call. The first thing I noted was that the signature was not mine. It was a skilled imitation, but it was not mine. The specific pressure of my signature at the downstroke of the A, the way I closed the loop on the N, the habitual forward lean I have had since secondary school. All of it present in the document, all of it slightly wrong. A person who had not studied my signature for years could not have produced it. The second thing I noted was the notary, Carolyn Marsh. I ran the name through the State Notary Commission database. Carolyn Marsh had allowed her commission to lapse 14 months prior to the date on the document. On the date the power of attorney was notarized, she was not a registered notary. The document was invalid on its face. The property was not at risk, but the crime was committed, and I had no intention of leaving it as something that had merely failed because of procedural gaps Vivian had not anticipated. I had every intention of closing those gaps myself, permanently, through every available channel. I told Dan that evening. I had spent the day on the phone with the estate attorney, with the realtor, and with 2 forensic document specialists I knew through my professional network. I had the full picture before I sat down with my husband. I did not want to present him with a partial account. I wanted him to hear the complete version once, clearly, so that there was no space for incremental processing that might soften the shape of it. I sat at the kitchen table and I said, I need to tell you what your mother did. He sat down. I told him in order. The realtor's call, the documents, the forged signature, the power of attorney, Carolyn Marsh and the lapsed commission, the buyer. I left that detail until last. The buyer, Vivian's sister Patricia, who had placed an offer on the cottage at $112,000 below its assessed value. The offer that Vivian, acting under the forged power of attorney, had accepted. Patricia, who would then have owned the cottage she had always believed should be family property, at a price Vivian had decided was appropriate for family. Dan sat at the table and did not speak for a very long time. I have been married to him for 4 years and I have learned his silences. This was not the silence of someone processing. It was the silence of someone dismantling something. He said, "She offered it to Patricia." I said, "Yes." He said, "Below assessed value." I said, $112,000 below. He said, "She accepted on your behalf." I said, "Using a document she forged." He said, "She forged your signature." I said, "Yes." He said, "And a notary who was not commissioned." I said, "Yes." He said, "The trust makes the sale void anyway." I said, "Yes." He said, "But she did all of it." I said, "She did all of it." He was quiet again. Then he said, "I am going to call her." I said, "I would like you to hear what I need to happen first." He said, "Tell me." I said, "I need a police report." I said, "I need the documents submitted to the DA's office." I said, "I need Carolyn Marsh reported to the State Commission." I said, "I need Patricia's participation investigated because she offered below value on a property she had reason to know was not properly listed." He said, "You think Patricia knew?" I said, "Patricia is Vivian's sister, and she offered $112,000 below assessed value on a property that had no reason to be underpriced, unless the price had been set by someone with a personal reason to sell it cheaply." He looked at me. He said, "Yes." He said, "Yes to all of it." He said, "And I'm going to call my mother first, because I need her to understand what is coming before it arrives." I said, "I thought you would want to." He said, "Anna." I said, "Yes." He said, "I am going to say the right thing." I said, "I know." He said, "I need you to believe that." I said, "I do believe that." He called Vivian. I was in the other room. I did not listen at the door, but I heard the rhythm of it from the hallway, the specific cadences of a conversation where one person is speaking with precision and the other is cycling through responses that are not adequate to the precision. I heard her say, "I was trying to help." I heard him say something. I heard her say, "The cottage should be in our family." I heard him say, "It is in our family." He said it loudly enough that I heard it clearly. "The cottage is in our family. It has always been in our family. You decided it was not, and you committed a crime to act on that decision." He was quiet for a moment. Then he said, "A police report is being filed." He said, "A DA investigation is being opened." He said, "I am telling you this now, so you understand that when those things happen, they are not a surprise." She said something. He said, "No." He said, "There is nothing to discuss." He said good night. He hung up. He came into the kitchen. He sat down. He said, "She said she was doing it for me." I said, "I know." He said, "I told her she was doing it to you." I said, "Yes." He said, "She did not understand the difference." I said, "I know she didn't." He said, "That might be the most clarifying thing about all of it." I said, "Yes." I said, "It is." The police report was filed the following morning. I filed it myself. The officer who took the report had a specific expression when I laid out the documents. The kind of expression that people who work with paperwork all day have when they encounter paperwork that is worse than usual. He said, "You identified the notary discrepancy yourself." I said, "Yes." He said, "What do you do professionally?" I said, "Forensic accounting." He said, "Right." He said, "This is going to move quickly." He said, "Forgery and fraud charges are straightforward when the documentary record is this complete." He said, "The notary's participation makes it more serious, not less, because it indicates a knowing facilitation of the fraud, rather than an informal forgery." I said, "What about the buyer?" He said, "That is a question for the DA." He said, "But if she purchased at a substantially below market price from someone she knew to be using a document of questionable validity, the circumstantial evidence of conspiracy is meaningful." He was right that it moved quickly. The detective assigned to the case contacted me within 48 hours. Her name was Detective Okafor, and she was methodical in the way I appreciated. The way of someone who understood that document crimes were built on small details, and who was not going to skip the small details. She requested the original listing documents from the realtor. She requested the notarization records from the State Commission. She requested my signature samples for forensic comparison. She interviewed the realtor, who confirmed Vivian had appeared in person, presented the documents and presented identification. She interviewed Carolyn Marsh. Carolyn Marsh declined to make a statement without a lawyer. Detective Okafor said that was a predictable response to someone whose commission had lapsed. She said, "It is not a statement of innocence." She said, "It is a statement of someone who knows what they did." The forensic document examiner confirmed what I had already determined. The signature on the power of attorney was an imitation of my signature. It was a practiced imitation, which meant it had been prepared, not improvised. It had been studied. Someone had looked at my signature on multiple documents over time and practiced reproducing it until the reproduction was close enough to submit. I sat with that for a moment. Not at my desk. At the kitchen table. The specific image of Vivian studying my signature on documents over 4 years of our marriage. Birthday cards. Christmas letters. Form signatures. Any piece of paper that had passed through her hands and had my name on it. Studied. Practiced. Reproduced. Detective Okafor said, "The preparation indicates premeditation." She said, "This is not something that was decided impulsively." I said, "No." I said, "It is something that was decided and then built." She said, "Yes." She said, "The DA is considering charges of forgery in the first degree, fraud, and conspiracy." She said, "There is a separate question about the buyer's knowledge and participation." I said, "Patricia offered $112,000 below assessed value." She said, "Yes." She said, "That is a number that requires explanation." She said, "We are going to ask for one." Patricia's explanation, delivered through her own lawyer, was that she had been told by her sister that the property was being sold at a reduced price for family reasons. Her lawyer said she had no knowledge of any irregularity in the documents. Detective Okafor said that explanation was not consistent with the below-market offer and the family relationship. She said, "Knowing participation in the fraud will require more evidence than circumstantial inference." She said, "But the DA is reviewing the full record. The charges that proceeded against Vivian were forgery in the first degree, fraud, and obtaining property by deception." Carolyn Marsh was referred to the State Commission for operating as a notary with a lapsed commission and for participation in a fraudulent document. Her commission was permanently revoked. Patricia agreed to a plea arrangement that included restitution of her legal costs, withdrawal of the offer, and a formal acknowledgement that she had submitted a below-market offer on a property she had reason to know was not properly listed. She did not face criminal charges in exchange for that cooperation. I will tell you whether I think that was just... I will tell you in a moment. Vivian's case went through the courts over a period of 8 months. I will not walk you through each hearing, because that would be 8 months of procedural detail. That is not the point. The point is what happened at the sentencing, and what Vivian said in her statement. She was allowed, as defendants are allowed to make a statement before the sentence was handed down. She said that she had acted out of love for her son. She said that the cottage had been a source of tension in the family because it was not in the family's name. She said, "A wife's separate property is not a family asset." She said, "I was trying to correct an arrangement that was not fair to my son." The judge paused. The judge looked at her for a moment. Then she said, "Mrs. Sheridan, the arrangement you are describing was a legal arrangement made by two adult people who are married to each other, about an asset that was legally inherited by one of them." She said, "You did not have the authority to correct it. You did not have the authority to decide it was unfair. You did not have the authority to forge another person's signature, employ an unlicensed notary, and submit fraudulent documents to a real estate agent." She said, "The question of whether the arrangement seemed fair to you is not a question this court is in a position to adjudicate." She said, "This court is in a position to adjudicate what you did about it." Vivian received a suspended sentence and 3 years of supervised probation. She was ordered to pay restitution for legal costs. She was ordered to complete a financial literacy and ethics course as a condition of the probation. She was ordered to have no contact with the Keene Road property or its owners in any capacity. I want to tell you whether I think the outcome was just. I think the suspended sentence was lighter than the crime deserved. I think a first-degree forgery conviction with a suspended sentence is a sentence that benefits from the defendant being 61 and having no prior record. I understand the factors the court weighed. I do not think those factors fully account for the deliberateness of what was prepared over years, the practiced signature, the lapsed notary recruited, the buyer arranged, the family asset targeted. I hold both things at the same time. The sentence was what it was, and what she did was what it was. Both are in the record. Both are permanently documented. That is the most accurate version of the outcome I can offer. Let me tell you about Dan, because Dan is not Vivian's story. Dan is his own, and I want to give him that. Dan supported every step of the process. He did not ask me to soften anything. He did not ask me to consider her age, or her intentions, or her love. He said once, "She told the court she was acting out of love for me." He said, "I want to tell you something clearly." He said, "What she did in the name of loving me is one of the most disrespectful things that has ever happened to me, because she did it in my name. She used my name as a justification to commit a crime against my wife. She decided that what I wanted was property control, and she acted on that decision without ever asking me." He said, "I do not want property control. I want a marriage." He said, "She did not ask me because she knew what I would say." I said, "Yes." He said, "I'm saying it now for the record. The cottage belongs to you. It was your father's. He built the dock. It will always be yours, and being yours makes it ours. And that is the only arrangement I have ever wanted." I said, "I know." He said, "I want to go up there." I said, "This weekend?" He said, "Yes." We went the following weekend. I want to tell you about the cottage. I want to tell you what it is so you understand what Vivian decided she had the right to move. The cottage is a 3-room building on the east side of Keene Lake. My father bought the land in 1981 when he was 28 years old, and he built the structure himself over 2 summers with help from his brother. The dock he added in 1987. The dock is not architecturally remarkable. It is a dock. 12 feet of pressure-treated boards extending over water with a cleat at the end that my father used to tie off the small aluminum boat he kept there until the boat finally gave out when I was 17. The boards have been replaced twice. The cleats are original. My father taught me to tie a cleat hitch on that dock when I was 6 years old. He had a specific way of teaching things, patient and precise, and with the particular seriousness that said this is worth doing correctly. I tied and untied that cleat hitch approximately 40 times on that dock over the summer of my 6th year, until I could do it without looking at my hands. He said, "Now you can always tie up a boat." I said, "We don't have a boat anymore." He said, "You will have a boat." He was right. We had bought a small kayak the previous spring. It was in the storage shed behind the cottage when we drove up that Saturday morning. Dan got the kayak out while I unlocked the cottage. I walked through the 3 rooms. The kitchen with the mismatched mugs that had been there since before I could remember. The living room with the bookshelves that held the books my father had read every summer. Paperback mysteries and bird guides, and one extremely optimistic book about sailing that he had bought in 1994 and never completed. The small bedroom with the wooden headboard that had been in the family for 3 generations. I ran my hand along the headboard. The wood was cold and smooth, and exactly as it had always been. I went back outside. Dan had the kayak at the dock. He was crouching at the edge looking at the water. The June light was coming off it in a specific way. The best light of anywhere, my father had said, in June. I walked down to the dock. I stood at the end with the cleat at my feet. I looked at the water. Dan looked at me. He said, "It is still here." I said, "It is still here." He said, "Nobody sold it." I said, "Nobody sold it." He stood up beside me. We looked at the water together. The light was exactly right. The cleat was original. The boards had been replaced twice and would need to be replaced again in a few years, and I would arrange that, exactly as my father had arranged it. Choosing the right boards and making sure the cleat was right, and knowing that the dock was the dock because of the attention paid to it over decades. The specific and patient attention of a person who understood that things worth keeping required the work of keeping them. A forensic accountant who had spent 9 years learning to find the places where things were not what they appeared to be had found, on a Thursday at 11 in the morning, the place where her own life had been targeted, and had done what she did every working day. She had documented it. She had followed every available channel. She had not finished before it was done. It was done. The dock was ours. The water was June. The light was right. Here is my question for you. If you found out your mother-in-law had forged your signature and listed your inherited property for sale, while your husband said nothing for years about his mother's belief that the property should be in his name, would you have trusted your husband the way I trusted mine? Tell me in the comments. I read all of them. There is one more thing. The professional dimension. Because I have debated whether to include it, and I have decided that it belongs in the story. 6 months after the case concluded, I was invited to speak at a financial crime seminar for attorneys and legal professionals in my state. I had spoken at the seminar before on other matters. This time I was asked to speak on document fraud in property transactions, specifically on the role of signature forgery in family estate disputes. I prepared a case study. It was anonymized. Every name was changed. Every identifying detail was altered. No participant in the seminar could identify any of the people involved from the materials I presented. I used it because it was, from a forensic standpoint, instructive. It showed the multiple layers of the scheme. The practice signature, the unlicensed notary, the below-market buyer, the trust structure that voided the transaction before it completed, the way the state database could be used to verify notary commission status in real time. 11 attorneys and 6 forensic professionals attended the session. At the end, one of the attorneys came up and said, "The trust detail is remarkable." He said, "Most people in the victim's position would not have had that protection." I said, "Most people have not had an estate attorney who anticipated this specific situation." He said, "Did you have any idea it might happen?" I said, "No." I said, "But my father's attorney had seen enough family property disputes to know that protection was worth building." He said, The person who targeted the property did not know about the trust. I said, no. He said, so the property was never actually at risk. I said, it was never at risk from the sale. He said, that she tried. I said, she tried completely. She built a practice signature over years. She recruited a notary. She arranged a buyer. She listed the property and accepted an offer. All of it was real. The crime was complete. The trust simply meant it could not have its intended effect. He said, what happened to her? I said, everything available. He nodded. He said, good. I said, yes. He said, good. We shook hands. I drove home. The seminar materials are filed in my office. The anonymized case study is in the folder that I keep on family property fraud, which has grown over 9 years to be thicker than I would like. But it is accurate. It is complete. And the case that opened it was one that ended with a dock that was still ours, on a lake where the June light was the best light of anywhere, and a cleat that was original, and boards that needed replacing, and a marriage that had been tested and had not broken. All available channels. Every single one. That is the end.